Basically, we'll talk about the goals of bankruptcy law, the different bankruptcy courts generally, the different types of relief in the different chapters, and a little bit about the special treatment of consumer debt. Chapter 7, I don't mean chapter in the textbook, I mean Chapter 7 under the U.S. Bankruptcy Code, is liquidation. This is sometimes referred to as ordinary or straight bankruptcy. The debtor turns over all their assets to the bankruptcy trustee, and the trustee's job is to sell non-exempt property and distribute the proceeds to the creditors. The remaining debts under Chapter 7 are discharged. You'll see that that's going to be different under other chapters. Chapter 7 is available for any person, individual, corporation, or partnership. And persons in quotes because corporation or partnership is treated as a person for Chapter 7 liquidation purposes. Notice the different types of organizations that cannot file under Chapter 7. Chapter 7, or straight bankruptcy, is started by filing a voluntary or involuntary petition in bankruptcy with the bankruptcy court. The bankruptcy court is the U.S. District Court Bankruptcy Division. If the debtor files a petition, that's called voluntary, and if the appropriate number and size creditor files a petition rather than the debtor, that's involuntary. Prior to filing, the debtors or debtor must receive credit counseling within 180 days of filing and submit a certificate of that credit counseling. And it has to confirm the accuracy of the contents of the filing, and an attorney must file an affidavit informing the debtor about other chapters of bankruptcy. There are some schedules under Chapter 7. The debtor needs to list both secured and unsecured creditors, their addresses, and the amount of debt they owe, and a statement of the financial affairs of the debtor. They also need to list all properties owned by the debtor, including their property claimed by the debtor to be exempt, and current income and expenses, that certificate that we mentioned of credit counseling, and proof of payments received from employers within 60 days prior to the filing of the petition. They also need to state the amount of monthly income, itemized to show how the amount is calculated, as well as a copy of the debtor's federal income tax return for the most recent year ending immediately before the filing of the petition. There's the substantial abuse and means test. The basic formula is to take the debtor's average monthly income and compare it to the median income in areas where he lives. If it's below the median income, there's no presumption of abuse. Also, there's applying the means test to future disposable income. If the debtor's income is above the median income, then further calculations are necessary. This would include a calculation of disposable income. Additional grounds for dismissal would include a conviction of a violent crime or drug trafficking, or the debtor fails to pay a post-petition domestic support obligation. And then the order for relief, if the filing is proper, the filing itself is the order for relief. The order for relief is granted by the bankruptcy court. The involuntary bankruptcy is, again, by the creditor forcing the debtor into bankruptcy. If 12 or more creditors, 3 or more which have unsecured claims totaling at least $14,425, they join in the petition. If it's less than 3 total creditors, 1 creditor has to have that amount of debt. The debtor can challenge this involuntary bankruptcy, but the court will enter an order for relief if the debtor is not paying debts as they come due, or the debtor was in receivership for the 120 days before the filing of the petition. There are penalties for frivolous petitions against debtors. If a court dismisses an involuntary petition, a creditor may be required to pay fees and costs, in some cases even punitive damages. The vehicle for staying off the creditors is called an automatic stay. It's granted upon filing of the petition, and it protects the debtor from all creditors. a creditor, which means basically a creditor can't commence their own action or continue legal action to collect individually. There are damages for knowing violations of an automatic stay. There are some exceptions, primarily around what kind of debt is protected, a domestic support obligation related to divorce support, custody, maintenance, investigations by security regulatory agency, secured parties, which we talked about earlier, can petition a bankruptcy court for relief from the automatic stay. And with each of these chapters, we look at all of the debtor's assets. It's called an estate and includes all legal and equitable interest in property. It includes property transferred in a voidable transaction and property which the debtor becomes entitled to within 120 or 180 days after filing. Proceeds and profits from property of the estate, after acquired property. Basically, the idea is to not just take a snapshot in time, but to look at proceeds, profits, things that were acquired afterwards, sales that were made immediately before, those type of things. Things like inheritance, property settlements, life insurance proceeds. The bankruptcy trustee is appointed by the court. Their duties include collecting assets and paying creditors in order of priority. And in terms of the means testing, they determine whether there's a substantial abuse. They file a statement within 10 days after the first meeting with the creditors. They have powers. The trustee has the right to strong-arm creditors to return the debtor's property. They have avoidance powers to set aside certain transfers. An example, if somebody were fraudulently transferring property to try to avoid it becoming part of the bankruptcy estate. And basically, the trustee stands in the shoes of the debtor and can assert any lack of capacity or lack of assent. Debtor isn't permitted to transfer property or make a payment that favors or gives preference to one creditor over another. For a trustee to recover payment, the debtor must be insolvent and transfer property for pre-existing debt within the previous 90 days. It could also give preferences to insiders. This avoidance power of the trustee extends to transfers made within 1 year before filing. Transfers that don't constitute preferences, for example, payment for services within 15 days, a payment must be made in the ordinary course of business and generally applies to debts that are not pre-existing. And they have the power to avoid fraudulent transfers. There are some exemptions for things that go in the bankruptcy estate. Here are some of them. Equity in the debtor's residence, burial plot. I refer to this as a homestead exemption, interest in a motor vehicle, personal goods. You don't have to memorize these dollar amounts. It just gives you an idea. Jewelry, other property listed in the statute, tools, a life insurance contract. You can just see some of the other exempted type property or rights. In terms of the homestead exemption, the idea is to provide protection for home equity. And there's some requirements in terms of residence and amount. The creditors do meet. The trustee calls that meeting and examines the debtor under oath. Creditors are claiming a portion of the debtor's estate, and each creditor must file a proof of that claim. Basically, if they don't file proof of the claim, then there's a problem later when they attempt to go after the assets of the debtor and they fail to respond. Debtor needs to file a statement of intention regarding the secured collateral. Distribute. We talked about this last time in terms of who the secured versus unsecured creditors are, and the fact that unsecured creditors are probably not going to receive much or anything. They get what's left over after secured creditors are paid off. And this is an exhibit kind of showing how that would work, and the image really just describes the different types of property that we mentioned: non-exempt property, properties that were transferred to avoid the estate, after acquired property under the statute, proceeds and profits from any of those things. And then, it goes first to secured creditors and then unsecured creditors. And then finally, if there's anything left over after all the debts are paid, the debtor. So at the end of that, they're discharged, and under all the chapters of bankruptcy, discharge means an avoidance or setting aside of debts, and there are some exceptions to this discharge. For example, back taxes, borrowing to pay taxes. It's all defined by statute. Fraud, support generally, retirement loans. And then Chapter 11 is reorganization. This is usually for corporations and other legal entities. The debtor and creditor formulate a plan under which the debtor pays a portion of its debt and is discharged. Same debtors are eligible as under Chapter 7. There is fast track Chapter 11 as for small business debtors. They have to have a certain dollar amount of their estate. There are workouts, which are private negotiation between creditor and debtors. The court can dismiss or suspend the proceedings if it's deemed prejudicial to creditors. Debtor in possession, where the debtor operates the business under court supervision. They have the same power as a trustee. Court could also appoint a trustee or receiver with strong arm powers. And there's what's called a creditors committee. And then it's kind of outlines some of the things that would be in a reorganization plan. Generally, it needs to be fair and equitable, identify classes, be able to be carried out reasonably, adequate means for execution, payment of tax claims for 5 years. So this reorganization plan is filed within 120 days after the date of the relief order. It's accepted, it's confirmed. The discharge is binding on confirmation. Generally just know the difference between the different chapters of bankruptcy in terms of who they apply to. Generally, like for example, we're talking about Chapter 7 being liquidation, Chapter 11 being reorganization. Chapter 12 is sometimes referred to as for family farms, fishermen. It defines what a family farmer is. This is not just small farm operations. And also an individual repayment plan under Chapter 13. This isn't for partnerships or corporations, and the statute gives specific income amounts. There is a good faith requirement. Chapter 13, the filing of the plans within 120 days after the order for relief. Some of this is the same across different chapters. Case 15.3 gives you a good example of Chapter 13 and discharge